I'm Charmaine Yost, the president of Americans United for Life, and it is my great honor to get to welcome you today to our symposium, Deconstructing Planned Parenthood v. Casey. We have such maps that detail. Thank you very much, and it is now my really great honor to be able to introduce to you Bill Saunders, who is our Senior Vice President of Legal Affairs, and he's going to moderate this and introduce to you this very distinguished panel that we have. And I know you join me in welcoming them. I'm very much looking forward to their analysis.
As Charmaine was saying, 20 years ago, almost to the month, or a month early, the Supreme Court issued an opinion which is in many ways a very bizarre opinion. It was a great moment in American legal history because there were 4 votes on the Supreme Court that day to reverse Roe v. Wade. In 1992, there were 4 votes on the Supreme Court to reverse Roe v. Wade. But Roe v. Wade, or the essence of Roe v. Wade, as the court said, was upheld in Planned Parenthood v. Casey by a vote of 5-4. While, as Charmaine said, we firmly believe that opinion contains the seeds of its own destruction and eventual overruling as we build a culture of life in the United States. It's true that it was a very disappointing decision that resulted in the entrenchment of abortion since. Now, the opinion, as I said, was 5-4, but in the 5 votes in the majority, there were 3 votes together called the plurality. And they issued an opinion that is in many ways a very bizarre and amazing opinion, claiming incredible power for the Supreme Court to rule the country and to form consensus where there was none. The authors of the opinion even indicated that they might not have voted for a right to abortion under Roe originally, but since it had been found, they weren't going to overrule it because it would damage the prestige of the court, which, if you just stop for a second, is an astounding, really unbelievable claim that somehow the Supreme Court has more prestige in a democratic society if it refuses to admit its mistakes. Well, the decision, in particular the plurality, has been subjected to withering criticism from a variety of sources. And perhaps the most eminent of all comes from our first speaker, Professor Michael Stokes Paulson. He has many achievements. He's a very distinguished professor of law at the University of St. Thomas. But rather than read what's in your program, as with each speaker, I'll introduce him separately. He will speak, and then I'll introduce the next speaker, etc. I just refer you to the program for more details. But we are proud to say he's a member of our board of advisors. Now, his critique of Planned Parenthood v. Casey has a title that you are not likely to forget. Simply, the worst constitutional decision of all time. And that's an understatement. I really sincerely hope that everyone here will read this article. It appeared in the Notre Dame Journal, the Notre Dame Law Review in 2003. It is an exhaustive, extensive critique of Planned Parenthood v. Casey from a variety of angles, which really superbly demonstrates it is the worst constitutional decision of all time. So, Professor Paulson.
Thank you, Bill, for that wonderful and perjurious introduction. I'm honored to be here, humbled to be here on this, well, what I regard as kind of a grim occasion. I'm usually an optimistic, cheerful guy, but my title is, that Casey is the worst constitutional decision of all time. Next month marks the 20th anniversary of what I think of as a judicial travesty and a deep human tragedy. Planned Parenthood versus Casey, as you've already been told, is the 1992 decision reaffirming by vote of 5-4, 20 years ago this June, Roe versus Wade. And it is certainly one of the most consequential and arguably, I think, the worst constitutional decision of the Supreme Court of all time. Like Roe before it, Casey embraced essentially an absolute constitutional right to obtain or commit an abortion of a human life. That is a right to kill a living human embryo or fetus. And I think we need to be clear about that to begin with. Abortion ends the life of a living human embryo or fetus. Now, I tend to be a controversial guy, but by that statement, I don't mean to be provocative so much as just clinically descriptive. Okay, the embryo is a living being, right? Abortion ends that life, and it is a living being of the species Homo sapiens. It is a living human life. The question of whether we accord moral status to that human life and protect it is a different moral question from actually what is being done. I think we have to be objective that what Roe created and what Casey reaffirms is a right to kill a living human being at its most vulnerable and earliest stages. Now, Roe made that a constitutional right, and the right is universally just about agreed to have no good basis in the text, structure, logic, history, or intention of the framers of the Constitution. No rule of law or principle supplied by the text of the Constitution, by any fair reading of the text, no rule or principle fairly derived from the Constitution's structure or internal logic or something that you could deduce from other clear propositions contained within the text, and no rule or principle traceable to any authoritative decision of the people, either as a matter of history or a matter of intention of the framers, remotely supports the conclusion in Roe versus Wade. Now, the striking thing about Casey, kind of its distinguishing feature, its really shocking feature, is that the court in Casey, a majority at least, agreed with all of that. I'm going to disagree with your count, Bill. I don't count 4 justices who thought Roe was wrongly decided. I count at least 6 and probably 7 justices who probably conceded and appeared to concede by their opinion that Roe versus Wade had been a fundamentally illegitimate decision. But they decided to adhere to it anyway with full awareness of its illegality and of its moral and human consequences for the petty, conceded purpose of preserving public perceptions of the court's own authority, prestige, integrity, and I would add, vanity. Now, that to me makes Casey a little bit worse than Roe. Casey stands as, I think, the most craven, most deliberate, most intentionally, premeditatedly lawless act of judicial activism and violence in our nation's history. Worse than Roe, and worse even than its nearest competitor, Dred Scott versus Sanford from 1857. And that's saying quite a bit. You know, my title is, this is the worst constitutional decision of all time. In the next 10, 20, 30 minutes? No, I'll keep it. I'll defend that proposition as best I can, and I'm going to just set out my criteria of what makes a Supreme Court decision a bad or an atrocious constitutional decision, and explain why I think Casey fits that bill, though I've already, telegraphed some of that. But first, I want to just talk about Casey's importance, objectively, okay? Casey is a hugely consequential decision, irrespective of your view on abortion, right? First of all, you've taught a seminar in law schools called Atrocious Cases, looking for the worst Supreme Court decisions of all time. It was trouble keeping it to a top 10 list. And the problem is, I don't know why this happened, it tended to attract atrocious students, so I gave up teaching them. Maybe it's just too depressing, a sort of thing. But here are my criteria in a nutshell. A Supreme Court decision is atrocious where it first misconstrues the Constitution and produces harmful or evil results. And I think that's pretty straightforward, right? If the Supreme Court decision misconstrues the Constitution but actually produces decent or acceptable results, we can't regard it as quite that atrocious. It's just an error. And if the Supreme Court decision correctly interprets the Constitution, and that yields a bad result, we can't really blame the Supreme Court justices. We just blame the Constitution. It's been faithfully interpreted. Okay? So for something to be wrong and atrocious, it has to be a decision contrary to the meaning of the words of the Constitution, not fairly derivable from its text, history, structure, or any other principle, that produces a harmful or evil result. And by harmful or evil results, I mean the sorts of things that people generally regard as harmful or evil. Death imposed on innocent people, oppression, slavery, deprivation of fundamental human rights, misery, discrimination, and indignity, kind of in descending order of importance here. Then I'd add a couple of other further criteria. Okay? The decision is a little bit worse when it's intentional, right? My dog knows the difference between being tripped over, and being kicked, right? Where the Supreme Court decision is intentionally, mischievously, deliberately wrong, I think that sort of accentuates the wrongness. And finally, where a decision tends to be generative of further wrongs, right? Where it has ripple effects or tends to perpetuate wrongs in a way that becomes hard to undo, that sort of aggravates the harm too. Now, in these criteria, Casey, I think, is public enemy number one, okay? I have my own pet list of top 10, but I won't indulge that right now. But what makes Casey the worst is that not only is it legally wrong, but it is deliberately wrong. The Supreme Court justices, or a majority of them, enough to make the difference, believed that Roe was an error, believed that it was a major error, and developed a doctrine of deliberate error entrenchment. Now, the other thing that is peculiarly annoying about Casey is it has a superficial veneer of legal plausibility, right? Lawyers are trained in the common law method. We respect precedent and stare decisis. And so they wrap this idea of error entrenchment in something that is plausibly legal. And that way it actually closely resembles the Dred Scott decision, which goes out of its way to create as much pro-slavery law as possible through like lawyers' tricks 101, okay? If you lean hard on the doctrine of stare decisis, though, I think it is wrong in principle and actually pernicious to say that you will prefer a Supreme Court erroneous interpretation of the Constitution to the Constitution itself. In fact, understood in that strong sense, I think stare decisis is not only a bad idea, it's actually unconstitutional. Think about it for a moment. Go back to Marbury versus Madison. The reasoning of the argument for judicial review is that the Constitution is supreme law, and anything inconsistent with it, any act of a subordinate authority, must yield to what the Constitution actually says. Now, in the specific context of Marbury versus Madison, that yields the idea that an act of the legislature contrary to the Constitution is void. By exactly the same reasoning, a judicial decision contrary to the Constitution should be regarded as void as well. Taken seriously, stare decisis is unconstitutional. But of course, the doctrine is not taken seriously. It becomes, in practical effect, sort of a dishonest, disingenuous cover for decisions that are actually made on other grounds. Notably, in Planned Parenthood versus Casey, in the name of stare decisis, the Supreme Court overruled two other cases and modified, somewhat slightly, its structure of Roe versus Wade. And that's all in the idea of stare decisis. The Supreme Court has overruled many cases before, and many since, where stare decisis seemed to get the old heave-ho whenever it was convenient to do so. When I speak to first or second year law students in constitutional law, and they say, well, what is the binding force of precedent? What is the rule here? I actually have to explain, and it makes a good gag line. Well, the rule of stare decisis is that the Supreme Court will stick to its decisions except when it doesn't. Right? And I have this article there, it's one of those listed, called Does the Supreme Court's Current Doctrine of Stare Decisis Require Adherence to the Supreme Court's Current Doctrine of Stare Decisis? And actually, if you investigate the criteria, and I deconstruct it this way, of Planned Parenthood versus Casey, you very quickly get to the conclusion that stare decisis doctrine does not require adherence to stare decisis doctrine, and that the Supreme Court stare decisis doctrine is incoherent on every form. Nonetheless, it gives it a veneer of legal plausibility, which brings me, obviously we know the moral stakes here, but it goes to the ways in which Planned Parenthood versus Casey was deliberate. This time they knew, right? Now you can make an argument in Roe versus Wade, they knew what they were doing, but if you go back and read Roe, it has this 1970s feel that they thought, that's what courts do, is make social policy. They'd become accustomed to it. I read that decision and I see lava lamps and bell bottoms and long sidewalks. Okay? By the time you get to 1992, the moral stakes have become clear and the legal consequences have become clear, right? You can't say of the justices who voted to reaffirm Roe that they knew not what they were doing. Rather, they knew that it was wrongly decided. They knew what abortion is, and for many of them, I think they understood the moral and human stakes of it. And they did it anyway. Now, supposedly, the first person to call out the Nazi card loses the argument. But isn't that kind of like being the guard at Auschwitz, having the capacity to stop the slaughter, but doing it anyway because you don't want to look bad to your bosses? And that's why I think it is sort of morally degenerate and craven. And then the last criteria is clearly Casey is generative of further wrongs. Okay? The whole idea of the error entrenchment theory that the Supreme Court embraces in Casey is precisely to entrench the abortion right, to immunize it from further attack. The Supreme Court actually goes out of its way to criticize the efforts to question the Supreme Court's doctrine. I'm in the second or third book of the Hunger Games series now, right? And it is strikingly President Snow-like, right? We wish to encourage people to embrace the authority of the state and the rightness of it. We wish to encourage people to embrace the authority of the Supreme Court and tell them how wrong it is to question it. And I think that makes Casey about the most authoritarian decision of all time. Do I have 2 more minutes? Maybe 1 more minute. Okay, go into my 2-minute joke. The back page, my outline, talks about sort of ideas for undermining Casey, and I'll give this the barest of sketches. We can talk more about this in the question of answer. It sort of lays out an agenda in sort of 3 broad levels. Okay, at the highest level, I think, as a matter of abstract principle, it is important for citizens, for lawyers, to challenge this myth of judicial supremacy, the no matter whatness of what a Supreme Court holds. Lincoln, as I've laid out in a really long, but I think interesting 50 or 60-page law review article, did not subscribe to the idea of judicial inerrancy or of the unthinking duty of the political branches and the people to go along with whatever the Supreme Court says, no matter how long. And some of my other articles have defended the proposition that if a Supreme Court decision is badly wrong, nothing in the Constitution makes their wrong decisions supreme as against other actors in our constitutional system who also swear an oath to faithfully defend and apply the Constitution. The constitutional vision is actually one of separation of powers, division of authority, and checks against its misuse. Okay, so that's at the level of high theory. Let's question this idea that Supreme Court said so, okay, we're done, let's all go home. Then I have a couple of specific frontal assaults ideas. And one is one that's being voted on in the House of Representatives today. I've been a big fan and advocate of the idea of pushing for a ban on sex selection abortions. In part, and I think you'll hear more about this from Erica, it turns on its head this perverted notion that abortion rights are needed to protect equality of the sexes, that a woman can't be a woman unless she has a right to kill her baby, okay? Press it with anyone who calls himself pro-choice. Do you support the right of a woman to abort a child because it is a girl? I give you the citation for a web article at Public Discourse's site, that's Robbie George's Witherspoon Institute site, called It's a Girl, okay? I think passing this sort of law it really does fly in the face of Roe and Casey's framework, but it challenges the underlying premise. It challenges the itness of the fetus, would the Supreme Court actually embrace a constitutional right to abort a child on the basis of the fact that it's a girl? I tend to think they'd blink and retreat, and that's a good idea. But look also where that gets you, okay? To concede that it's a girl or it's a boy is to concede at some level the humanity of the fetus. And once you do that, the game is up. So that's my wedge issue of the month or of the year or of the decade, and I think that's something we should push through. I'm going to skip the rest of it other than to note that Casey does give some concessions, right? It never permits an abortion to be prevented. But it does have some room for attempting to persuade women not to have abortions, and that's where ultrasound statutes come in, and I think those are constitutional, and they are persuasive. If you show people what they are doing, they will realize what they are doing, and they will not do it, at least not as often. Finally, going back to stare decisis, if we take the Supreme Court at its word in Casey, which is somewhat hard to do, they say that the doctrine of stare decisis is a doctrine of policy, not required by law. Well, let's put it to the test. Congress could abrogate the idea of stare decisis in abortion cases and require the Supreme Court to decide this issue afresh, stripped of the precedential effect of Roe versus Wade or Planned Parenthood versus Casey. Once there are enough justices on the Supreme Court who would take this seriously, it removes the barrier of stare decisis and might provide a way for actually overruling Roe and overruling Casey. Thank you.
You know, the so-called right to abortion has always rested very uncertainly in the Constitution, searching for some kind of mooring. As Professor Paulson was talking about, for you non-lawyers in the room, there's a question of, is it somehow present in the due process rights and substantive rights attached to that? And as you know, Roe used an implied right to privacy to find a right to abortion. Planned Parenthood v. Casey found an incredibly expansive liberty right to ground the right to abortion. But currently in the debates, particularly in the legal literature, the question is, well, does a right to abortion rest in what's called equal protection, which is another clause in the Constitution? And our next speaker, Erica Bakayaki, is going to take this on. I want to mention to you and recommend to you again her article that is called, it's from the Harvard Journal of Law and Public Policy, and I can tell you as a lawyer, this is a very prestige journal. This is a great piece. It's called Embedded Equality, Debunking Equal Protection Arguments for Abortion Rights. So she directly takes on this claim that not in due process, but in equal protection is where you find a right to abortion. She's a brilliant young lawyer and scholar, and we welcome her.
Thank you. It's great to be here. It's an honor to be here among so many great, wonderful, impressive people. So for pro-choice feminist legal advocates, the Equal Protection Clause, not privacy or substantive due process, has always been the desired constitutional justification for abortion rights. Amicus briefs arguing as much were filed in Roe and in many, many cases since. Roe, of course, steered clear of such reasoning, as Bill noted, but in Casey, the plurality's opinion snuggled up close enough to get mouths watering. You, of course, remember Justice O'Connor's words, quote, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by abortion, and economic and social developments have relied on abortion, and the capacity of women to act in society requires abortion." Justice Blackmun's concurring and dissenting opinion is even more explicit, quote, "A state's restrictions on a woman's right to terminate her pregnancy implicate constitutional guarantees of gender equality." And Justice Stevens, Roe is an integral part of a correct understanding of both the concept of liberty and the basic equality of men and women. So though not holding as much, Casey's dicta sets the stage for a future case in which equal protection becomes the constitutional justification of choice. Ruth Bader Ginsburg joined the court just 14 months after Casey was decided, yet Justice O'Connor's words could just as well have been Ginsburg's. Indeed, in the years leading up to Roe and beyond, Ruth Bader Ginsburg, the scholar and attorney, was perhaps the leading pro-choice feminist proponent articulating the equality rationale for abortion rights. A decade and a half after her arrival on the court, Justice Ginsburg would finally make this view officially known in her stinging dissent in the 2007 partial birth abortion case, Gonzalez v. Carhart. Quote, "Legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature." We are now, of course, quite familiar with the use of autonomy arguments for abortion rights, but how might women be denied equal citizenship stature by abortion restrictions? Justice Ginsburg doesn't say explicitly in her Gonzalez dissent, but her use of this phrase in sex discrimination cases gives us some clue of what she is up to. So let me explain. Before Justice Ginsburg's appointment to the D.C. Circuit Court of Appeals in 1980, she was a superstar ACLU attorney whose amicus briefs and oral advocacy before the Supreme Court in the 1970s, in cases such as Reed v. Reed and Frontier v. Richardson, shaped equal protection jurisprudence governing sex discrimination. She sought to persuade the court in case after case that sex role stereotyping, that is, whether the relevant statute defined women as homemakers and men as breadwinners, ought to be the constitutional test by which to adjudicate sex discrimination cases. And she succeeded. Even Chief Justice Rehnquist would embrace Ginsburg's anti-stereotyping view in the 2003 case sanctioning Congress's authority to pass the Family and Medical Leave Act, Nevada v. Hibbs. So what do you suppose is the phrase that Justice Ginsburg employs to describe the overarching equal protection principle discernible throughout the court's sex discrimination cases since their advent? Equal citizenship stature. In the 1996 Supreme Court case, United States v. Virginia, Justice Ginsburg writes, quote, "Since Reed versus Reed in 1971, the court has repeatedly recognized that neither federal nor state government acts compatibly with the equal protection principle when a law or official policy denies to women, simply because they are women, full citizenship stature. The term full or interchangeably equal citizenship stature is thus meant to contain the entire body of sex discrimination jurisprudence in its definition. Justice Ginsburg's use of it in the recent partial birth abortion case is then a not-so-veiled attempt to bring abortion law into the fold of sex discrimination law. And assuming Justices Sotomayor and Kagan are on board with this overwhelming trend in pro-choice legal scholarship, Justice Ginsburg's view is just one vote away from making abortion rights all about equal protection. Yet, current equal protection jurisprudence, even with Ginsburg's prints all over it, does not govern legislation that regulates real, physical, biological differences between men and women. And in United States v. Virginia, Justice Ginsburg admits as much. Current equal protection jurisprudence is interested solely in preventing the legal perpetuation of traditional sex role expectations, not in maintaining a misguided illusion of the biological identity of the sexes. Statutes thus violate equal protection when they invoke biological differences to enshrine traditional views of family and workplace relations. They steer clear of violation when they regulate in mere recognition of such differences. As Justice Kennedy wrote in the 2001 case, Nugent v. INS, quote, "To fail to acknowledge even our most basic biological differences risks making the guarantee of equal protection superficial and so disserving it," end quote. Thus, when abortion restrictions regulate the biological state of pregnancy, because of course it is the physiological process by which new human beings enter the world, they simply do not implicate equal protection. In an effort to avoid this biological reality that men and women are not similarly situated when it comes to pregnancy, which of course is the threshold requirement in equal protection litigation, proponents of equality arguments attempt to describe the decision to abort at a higher level of generality. So for instance, men and women are similarly situated in their common desire to, in Casey's articulation, define their views of themselves and their places in society. Or in Justice Ginsburg's words, both men and women have the, quote, equal opportunity to aspire, achieve, participate in, and contribute to society based on individual talents and capacities. These statements, in and of themselves, are, of course, beyond dispute. The court in modern times has properly renounced historical views of women as dependent creatures, incapable of rational decision-making, recognizing instead that women, like men, are self-governing, competent individuals. Preventing women from determining their life course and from shaping their own destinies most certainly denies them the freedom and equality so prized by democratic peoples and inscribed in the Constitution. Goals and aspirations, decisions and destinies, however, are never formed by disembodied minds. Rather, embodied individuals, actual men and women, are the relevant goal and decision-making agents. The equality argument for abortion suggests that because the professional and personal lives of men need not be interrupted by an ill-timed pregnancy, because frankly, men can just walk away, equality requires that the professional and personal lives of women ought not be interrupted either. But for the law to treat women and men equally, and this is what current equal protection jurisprudence seems to get, it cannot ignore the biological reality that men and women's bodies differ significantly with regard to reproduction. One need not be a biologist to know that men's physiological design makes them reproductively autonomous by nature, that is, physically detached from a pregnancy that may result from the sexual activity in which they engage. This reproductive autonomy or physical detachment from pregnancy enables irresponsible men to shirk the duties that come with siring offspring. Women are not so designed. The life-giving consequences of the potentially procreative sexual act confront them with immediacy and gravity, a vulnerability that callous men have exploited throughout human history. The legal availability of abortion has worked to detach men even further from the potentialities of sexuality, offering men the illusion that sex can finally be completely consequence-free. The trouble is that for women, sex that results in pregnancy is never consequence-free. Indeed, it is fraught with consequence. Women must act affirmatively and destructively if they are to imitate male reproductive autonomy. Abortion rights legal scholars argue that it is abortion's opponents who would, in a biologically determinist fashion, create legal doctrines from biological facts. Yet it is pro-choice advocates who select a particular biological reality, detached male sexuality, to determine how sexual equality should look when it comes to pregnancy. In agitating for abortion to achieve this male-like reproductive autonomy, pro-choice feminists are holding up male physiology as the human norm. Seeking to mimic the autonomous, child-abandoning male through abortion would seem rather contrary to feminist ideals, but Justice Ginsburg tells us what's at stake. Quote, "Women's ability to realize their full potential is intimately connected to their ability to control their reproductive lives through abortion. Women can reach their full potential," Justice Ginsburg intimates, "only by imitating men." The irony in pro-choice feminist reasoning here is tragic in its proportions and yet so rarely acknowledged. The early American feminists fought against the categorization of women as legal non-entities or viewed more charitably as united in the legal personhood of their husbands. Pro-choice feminists now argue that the achievement of legal equality in the modern era requires women to deny that which distinguishes them most from men. Historically, women were regarded as legally incorporated into men. Now, women are equal only insofar as they imitate men. Historical feminists fought the former. Today's pro-choice feminists encourage the latter. And this is the real problem with equality arguments for abortion rights. They depend upon a feminist philosophy that reduces sexual equality to sameness, unwittingly setting up the male experience, and especially the male body, as the norm. In a legitimate attempt to get beyond the traditional idea that women's reproductive capacity should be determinative of women's lives, pro-choice feminist legal thinkers have jettisoned the significance of the body altogether. In rightfully arguing that pregnancy is more than just a biological reality, they discount the fact that pregnancy is fundamentally a biological reality. Acknowledging this biological reality that the human species gestates in the wombs of women need not necessitate the current social reality that women are the primary and too often sole caretakers of their children, or the social arrangements in which professional and public occupations are so hostile to parenting duties. Biological realities need not determine social arrangements, but in ignoring or denying biological realities, we make it far more likely that social arrangements will end up denigrating biological difference, and that's a whole lot of what we see today. Abortion works to perpetuate both the cultural devaluation of motherhood and of parenting generally, and the social conditions that pro-choice feminists rightly argue are inhospitable to child-rearing. Abortion eliminates the incentive to make institutional change. It is inequitable that becoming a parent should disproportionately impact mothers' economic well-being as compared to fathers. It is devastating that fathers can abdicate their parental duties with incommensurate financial and social repercussions, leaving many women to raise children in deplorable conditions. But abortion does nothing to change those conditions. Rather, the remedy is to rectify the imbalance of parental responsibility, as well as the marketplace mentality which disfavors family obligation. Pro-choice feminists have sought to make the same what nature has made different by encouraging pregnant women to imitate male reproductive detachment through abortion, rather than legally requiring men to become more demonstrably attached to the children they father. The law is tasked not with finding a way for women to be imitators of reproductively autonomous men, but with persuading, or if necessary, compelling men who impregnate women that they are equally responsible for the well-being of the child their union created. The cultural view we take of unborn human life, whether it be high or low, translates directly into the respect or disrespect pregnancy affords a woman, both socially and professionally. If pregnancy is just like any other medical condition, or worse, is a condition treated as a burden to women, a state that symbolizes their inability to compete with wombless men, pregnancy will never be accorded the respect and accommodation it deserves. Not all women become mothers, but those who do so depend upon a cultural esteeming of the state of pregnancy, the nurture of an individual, unique, dependent human being for their social and professional support. To belittle the moral status of the unborn child is to belittle the state of pregnancy, and so the pregnant woman. Indeed, the sacrifices that pregnant women endure during their pregnancies would be more honored and perhaps more rewarded were we honest about the dignity of the human beings who have been entrusted to their care. In denying the significance of the body, abortion rights advocates do a disservice to women who throughout human history have been denigrated because of their physical differences from men. The plight of women who have children, whether professional or poor, married or single, will continue to be viewed as theirs alone until pregnancy and motherhood are properly esteemed, rather than viewed as simply another lifestyle option in a post-Roe culture taken by choice. Taking seriously the body does not mean that all women share a nurturing nature that makes them solely fit for the care of children, or that men lack the capacity for such caretaking. Experience shows that both women and men are capable of caretaking and more publicly minded activities in varying degrees, depending on each individual. Taking the body seriously does mean recognizing, however, that with the woman's body comes the potential for becoming a mother and an actual maternal duty should she become pregnant. Because men's duties as fathers are not as deeply inscribed in their bodies, the law, if it is to uphold a genuine equality of the sexes, must act to educate and, if necessary, compel men to embrace their paternal responsibilities, the fulfillment of which our society so ardently needs. Thank you.
again, as with the other speakers, I'll refer you to your program for a complete biography. Clark Forsythe, who's our next speaker, has been with Americans United for Life for over 25 years. And while that might tempt you to think of him as the grand old man, his youthful appearance belies that, and he has the youthful capacity for constantly thinking up new ideas on how to create a culture of life. Clark.
Well, thank you very much, Bill. Thank you all for coming this afternoon. One of the foundations of the Casey decision is, unfortunately, often overlooked, and that's what I want to get into this afternoon. In Casey, the court dramatically changed the rationale for abortion rights and for its control of the abortion issue from history to sociology. The court said that Roe could not be overturned in 1992, that it had to stick with Roe versus Wade through stare decisis because of the reliance interests of women in abortion as a backup to failed contraception. And for shorthand, I'm just going to refer to that as reliance. So I'm going to talk about the significance, the source, and the defects of the reliance interests. And because I couldn't get those three to rhyme, you'll know why I went into law instead of politics. But reliance is the whole ballgame when it comes to the Casey decision and the court's continued control of the abortion issue. And I don't think that's an exaggeration. In other words, there's no majority on the Supreme Court today that will defend a historical right to abortion, no majority on the Supreme Court that believes that an abortion right is deeply rooted in American law and tradition. There's no majority on the Supreme Court that holds to Roe and Casey because of a lack of information about fetal development or fetal personhood. And those who think that these are important to the justices, I think, simply misunderstand the significance of what happened in 1992 in Planned Parenthood versus Casey. And because I just have a few minutes, I wanted to refer you to my article in Texas Review of Law and Politics, copies of which are available here today, on the tragic failure of Roe versus Wade, which goes on at quite length about the reliance interests and critiquing the reliance interests. And I'm going to update those arguments in my forthcoming book, Abuse of Discretion, The Inside Story of the Supreme Court's Creation of the Right to Abortion. But reliance is the glue that holds together a majority of the justices today behind Roe versus Wade. And I wish I could say that the solution to reliance interests was as easy as storming the Bastille, but it's more like a matrix overlay on an Inception overlay on a national treasure scenario. It's really quite that complicated. And I suppose some might ask, well, how is reliance retain its power if two of the three justices who wrote the plurality opinion, namely Justice Souter and Justice O'Connor, are not even on the court today? But reliance retains its power in the person of Justice Kennedy, the third author of the plurality opinion in Casey, and more importantly, I think, in the general pragmatic cast of American legal culture. And reliance is mirrored in public opinion that legal abortion, at least to some degree, is a necessary evil. The reliance rationale of Casey, stripped of its arcane legal terminology, is really and simply just good results. Has the court's management of the abortion issue yielded good results? Have women's lives been better with the court in control of the abortion issue? That's how pragmatic this issue really is. If Justice Kennedy retired next month, and I don't have any rumors that that's going to happen, we'd have a long, hot summer in the Senate. But the reliance interests would still maintain its pragmatic power. So the court's management of the abortion issue has long needed, to borrow a phrase, stricter scrutiny. There are several defects in the reliance interest rationale, but in the limited time I have today, I'm just going to go into 5 or 6 of them. And the first really starts with the thin basis for the whole reliance discussion in Casey, the source of the reliance interest. The court in Casey never asks whether reliance can be documented. It never asks whether reliance has been good for women. It just assumes that. But given the plurality's stake in the entire decision, and given the fact that they staked the decision on reliance, given what was at stake, as Mike Paulson has pointed out, what was the source for reliance in Casey? What did the plurality rely upon? Did they rely upon the record in the Pennsylvania case? Did they rely upon congressional studies, medical studies, congressional studies, studies by the World Health Organization? In fact, the entire basis cited by the court was 2 pages from this book, Rosalind Paczewski's Abortion and Women's Choice, The State, Sexuality, and Reproductive Freedom. 2 pages, and I've reprinted them in your materials. They're page 109 and just footnote 7 on page 133. And I would leave it to you to look that over. But I would suggest that these are hardly compelling arguments for the necessity of abortion for women's equal opportunity in American society. But the citation to Paczewski alone, and only Paczewski's book, for this huge theory of stare decisis and for reliance in Casey is not so surprising when you look back at the court's opinion in Roe v. Wade in 1973, because the court relied on makeshift arguments for major aspects of its abortion doctrine in Roe v. Wade itself. And to just give you the best example, central to the outcome in Roe v. Wade in 73 was the court's medical assumption, medical presupposition that abortion is safer than childbirth. And this is central to the opinions in Roe and Doe. It's explicitly referred to on just 2 pages, page 149 and 163 of the Roe opinion, but it is central to the entire outcome of Roe and Doe and why they legalized abortion. But as I lay out in my forthcoming book, there were no trials in Roe and Doe. There was no evidentiary record. There was no evidence that abortion was safer than childbirth. The medical myth that abortion was safer than childbirth was first raised in the Supreme Court, and it was hotly disputed in the briefs and in the arguments in the Supreme Court. But ultimately, the justices come up with 7 citations of medical articles in Justice Blackmun's opinion and Justice Douglas's concurring opinion, but none contain any data, any reliable data, to support the proposition that abortion is safer than childbirth. Second, the reliance interests rely on the justices' false paradigm that if Roe v. Wade was overturned today, abortion would immediately become illegal. But in fact, if Roe was overturned today, abortion would be legal in 42 or 43 states tomorrow. There would be no sudden change, as the justices assume in Casey. Abortion would be legal in 42 to 43 states simply because no enforceable prohibitions exist in those states, or there are state court versions of Roe v. Wade that would prevent enforcement. So the abortion issue, at least with regard to potential prohibitions, would return to square one in the state legislatures and be up for legislative debate and vote. Third, the proposition that abortion is safer than childbirth today can simply not be demonstrated. It's not credible, even though today it supposedly relies upon US data rather than Hungarian data, which was what the court relied upon in 1973. By definition, it does not take into consideration long-term risks. It is based on the mechanical comparison of the published abortion mortality rate and the published childbirth mortality rate. And again, in your materials, I've provided a 1-page outline that compares these 2 rates. Rates are made up of numerators and denominators, and the fact of the matter is that these 2 rates are incomparable because what goes into the numerators is very different and what goes into the denominators is completely different. So it's truly like comparing apples and oranges. So the central medical premise of Roe, that abortion is safer than childbirth, was false in 1973 and is simply not credible today. Fourth, reliance is contradicted by the reality of substandard practices that we see in abortion clinics today and that we've seen for 40 years. The court in Roe created, and unfortunately the court in Casey perpetuated, a public health vacuum. And this has led to the substandard practices in abortion clinics over the past 40 years, scandals like the Kermit Gosnell scandal in Philadelphia and the Stephen Chase Brigham scandal in Maryland and Pennsylvania over the past several months. But the scandals have gone on year after year after year in state after state after state because of the public health vacuum that the court created. And if you're interested in reading more about this, I lay this out at length in an article that I've published this month with Brad Kerr in the Villanova Law Review entitled A Roadmap Through the Supreme Court's Back Alley. The justices are simply incompetent as public health administrators, but that is precisely the role they assumed in Roe versus Wade. Fifth is the growing international data on the long-term medical risks of abortion. When looking at the international data, I want to emphasize that data, public health data, needs to be handled carefully. And I think there's especially two things to keep in mind. First, the studies focus upon, the language they use is increased risk. They focus on increased risk after abortion, which is not necessarily the same as causation, though increased risk and other indicators may eventually prove causation. And secondly, there are, of course, studies, the medical studies that find no increased risk after abortion. And these obviously need to be taken into consideration. Nevertheless, over the last 2 decades, in the 20 years since Casey, the number of peer-reviewed medical studies finding an increased risk after abortion from many different countries has grown considerably. Medical studies over the last 2 or 3 decades have created substantial data on 5 or 6 main risks from abortion. Increased risk of placenta previa after abortion, increased risk of preterm birth, increased risk of mental distress or suicide, loss of the protective effect of a first full-term pregnancy from breast cancer, and an increased risk of drug and alcohol abuse. There are now more than 120 peer-reviewed medical studies from many countries showing an increased risk of preterm birth after abortion. And there are now more than 100 medical studies, peer-reviewed medical studies from many countries showing an increased risk of psychological trauma after abortion. 6, there is the growing data that legalized abortion has not been necessary for maternal health or improving maternal health or promoting maternal health. Last December, for example, a study was published in Ireland that compared maternal health trends in Ireland, where abortion is prohibited, with maternal health trends in surrounding countries like Scotland and England, where abortion is widely legal. And the study found that Ireland had lower maternal mortality rates and better maternal health trends than Scotland or England. A similar study was published just this month in the online journal PLOS ONE, which looked at maternal mortality data in Chile over the past 50 years. And that study found that over the past 50 years, while Chile has prohibited abortion, the maternal mortality rate has dropped significantly. And even after Chile tightened its abortion prohibition in 1989, the maternal mortality rate continued to decline significantly. So, to close, I have no doubt whatsoever that Roe versus Wade will be overturned. Roe will fall, I think, first and foremost, from its own extreme scope. The justice's expansion of the right to abortion from the first trimester to viability and beyond was done arbitrarily, and it isolates the U.S. as one of only 3 nations around the globe that allows abortion for any reason after viability. Frankly, Roe is simply way out of line with international standards. Roe and Casey have created a public health vacuum that no one can fill. And the court's edict requiring the states to allow abortion for any reason at any time increasingly conflicts with public opinion, as the recent Gallup poll this month shows. The growth of legal protection for the unborn child in criminal law and tort law has grown impressively over the last 20 years. And frankly, if truth be told, much of the public authority of Roe versus Wade is simply based on fear. The public fear that chaos would result if Roe versus Wade was overturned and the issue was returned to the states. But overturning Roe means that the issue will return to the state legislative process and the states, the local level where public opinion will be better aligned with public policy. Thank you for coming this afternoon. I welcome your questions.
Okay, we have time for some questions. I just want to mention a couple of things. We have a microphone, so if you raise your hands, I will recognize you. A couple of things, just preliminarily. One is, please make the questions relevant to Casey. If you have other questions for Americans United for Life on other issues, we have our press people here and lawyers here, and we can talk to you afterwards, or you can send inquiries to press@aul.org. Also, when you ask your question, please identify yourself and your organization, and please try to make the question brief, as we don't have a lot of time. Okay, any questions? Okay, Richard.
Could you identify yourself, please, and your organization?
Richard Dorflinger, U.S. Conference of Catholic Bishops. Professor Paulson gave one answer to this, but I wonder if the other panelists, too, could answer the question, what kind of law would you next like to see lined up to go to the Supreme Court to put the next nail in the coffin of Casey?
Well, contrary to, I think, common wisdom, it's not necessary for the court to address an abortion prohibition in order to revisit Casey or Roe. The court can do that on any abortion regulation that arguably conflicts with Roe. And I think that the most important regulations and cases to take to the court are those that address the reliance interests in any dimension. That might be informed consent laws, it might be an ultrasound law, it might be a prohibition at 20 weeks. It could be virtually any regulation that raises issues relevant to the reliance interests.
Yeah, I guess all that I'd add is that I'd really like to see, rather than pro-life legal advocates focus so much, you see these kind of referendums here and there in states on personhood. And I just feel like, people aren't getting it. I mean, it's sort of a straw man. We really shouldn't see a difference between personhood and human and, just sort of human nature, the status of being a human being, and yet Americans aren't getting that. But I think Justice Kennedy seemed to open something up that in Gonzalez v. Carhart that Helen Alvarez has written about. And that is the use of basically family law to talk about abortion. And just instead of sort of saying, the unborn child should be rights-bearing as one who is a person, a legal person, we could say that being a human being, conceived by, his or her mother or father, that human being is a child. And I think once you concede the humanity, which pretty much everyone has done except kind of pro-choicers on the street, it seems like, who don't kind of get that the pro-choice advocates and their leaders have conceded humanity. It seems to me once you concede humanity, that the next step, not much of a step, is just to say that there's an unborn child there, and that child is due parental duties. And I talked about maternal, and I think especially paternal duties, we really need to talk about, but that's what, we already do that in family law. And I think the problem with Justice Kennedy's discussion of it, and also in the South Dakota legislation, was that it sort of relied on this subjective kind of relationship between the unborn child and the mother, as if mothers had this nurturing, feeling for the child, and therefore we shouldn't, interrupt that. And I think that's not the way to go. I would just go, because obviously there's not that kind of feeling, and for most people who seek abortions, or else they wouldn't be seeking abortions. I think you just have to go the objective route. If there is a child and we owe duties to that child. And I mean, I think it comes straight out of common law that, and Frank Beckwith has actually a great quote on this, which I should just, he's a philosopher, and I'll just end with that, is he says, "The parents of the fetus are responsible for assisting it because they are in fact responsible for bringing into existence a being that is needy by nature and thus are responsible for its neediness." In common law, we have a sort of common law duty to care for one to whom, we put in harm's way, so to speak, and by engaging in an act that is potentially procreative, and we should probably pay more attention to that, that brings into being a child who is vulnerable, dependent on his or her mother for sustenance, and also obviously his or her father once he or she is born.
Let me just add a quick thing. Sex selection prohibitions, I think, are great for the reasons I've mentioned. I also think we could benefit from statutes altering the definition of health from that embrace in Doe versus Bolton and challenging the Supreme Court directly on that front. I love ultrasound. It's like 20 years ago when one of my friends, when she was pregnant, she said, Michael, all we have to do is show people that ultrasound, and that will change things. I think that will actually reduce deaths, and I think it's one that could actually be upheld within current framework.
Another question?
Let me add real quickly, Richard, you won't be surprised to know that Clark, as usual, is being extremely humble. One of the successes that we celebrated this year in particular was the passage in Arizona of a late-term abortion ban, and one of the reasons we were so excited about that is that bill was based on an intellectual architecture that Clark has developed, that instead of being your he mentioned the late-term ban, but this one particularly marries together the interests of defending the baby and defending the health of the mother. And so it's unusual in the way it's constructed in working to target the reliance interest at the same time that you're focusing on the baby. So we see that as being a particular success that we've had in this past year.
Others? Questions? Where are you, Peg?
My name is Matthew Clark. I just graduated from the Liberty University School of Law. Thank you. I had a question. Professor Paulson brought up at the end of his speech, one of the things that we need to do is we need to be explaining to people the dangers of this myth of judicial supremacy. Obviously, it's a horrible thing, as we saw in Casey. I think it was Justice Jackson, if I remember right, who said, yes, the court is bound by the Constitution, but the Constitution is what we say it is. It's a very dangerous concept. So my question is, how do we get people fired up about this, especially people who are non-lawyers that might not see just how blatantly the court defies the Constitution and its opinions? What are the ways you get the word out? How do you get people fired up so that we can change this?
Well, I suppose that falls to me. I don't know. I'm open to suggestions. You know, I go make speeches. I write law review articles. You know, there's a limit to what you can do from an academic perch. Maybe, you know, this idea is so entrenched that, you know, the Supreme Court has spoken. You know, about the only thing that made me sad the day that Al Gore conceded was that he said, the Supreme Court has spoken, and therefore, you know, and I say, well, no, that's not the right reason. The right reason is that the other guy got more votes than you did. But, you know, I do have some fair degree of confidence that the Supreme Court will, by continuing to shoot itself in the foot, gradually undermine in public perception the idea that whatever it says is a sound interpretation of the Constitution. I think it would be great if a presidential candidate would actually embrace the position that the president has an independent duty to interpret the Constitution faithfully and will resist with all the powers at his disposal erroneous Supreme Court decisions in any way he can. I think that, you know, that's what Lincoln did, right? And, you know, he rose to national prominence on the basis of that. And the whole tenor of the argument against him was that you are acting as a lawless devil. You know, the election of Lincoln is electing someone who's anti-constitutional. So let's look for another Lincoln.
And Michael, thank you for that wonderful response, because it reminds me, we have as a panel forgotten to mention one of the essential points that we wanted to make today, which is that one of the lessons coming out of Casey, and Michael's introduction alluded to this, is how important the appointment role of the President of the United States is. And as we go into this election, it's key that we continue bringing that point back in front of the American public, because this will be so essential in the next administration. This next president will have the ability to shape the Supreme Court for the next time we have a shot at overturning Roe.
Okay. Ed, did you have a question?
Professor, I think you alluded to this, but isn't the ultimate irony of stare decisis in Casey the fact that the court overturned a decision that was only 6 years old, the Thornburg decision, which of course has permitted us to legislate in some of the areas that we've been legislating in for the past 20 years?
Yeah, I mean, that's one of the many ironies, is that, you know, in the name of stare decisis, the Supreme Court overrules a couple of cases and modifies its own prior decision. You know, it's like, well, what kind of version of stare decisis is that? What it really is common law judicial lawmaking and political compromising. I mean, it is important to say that this version of stare decisis not only selectively applied, right? You know, stare decisis didn't keep the Supreme Court from overruling Bowers versus Hardwick or a number of death penalty decisions. You know, they adhered to it as a principle of convenience. But the other thing is, you know, that's not really what they were doing. They were not adhering to a principle of stare decisis in Casey.
Okay, we could probably have one more. Okay.
Sam Casey, Law of Life Project. This one I think is directed to Professor Baldiacci, Erica. The crossover between family law and perhaps in some response to Richard's question as well. What about the burgeoning number of frozen human embryos about whom couples are contesting more and more, particularly right now in the Montana Supreme Court? Is this an area of constitutional development where, for example, the woman is being denied in Montana her right for reproductive choice? She cannot have any children biologically her own unless she can gain custody of these human embryos who are in a petri dish, and therefore no liberty interest is implicated directly.
Yeah, I mean, I'm certainly not an expert in all the areas of bioethics. I think Bill could probably address that question. But I mean, I would say that because of, you know, allowing something like, you know, in vitro fertilization, which, you know, many feminists have difficult times with on, from a feminist perspective, just sort of the commoditization of women, of, you know, children and all that, that has basically, you know, by thinking that we can create in a petri dish, we've really taken away the idea of sort of the centrality of looking at the children and their rights and our duties to them. And I think you're right that I don't know, you know, the specifics on the litigation there at all. But I think, you know, to look at how we might regulate that industry, especially trying to be child-centered and looking at, you know, pro-woman reasons to do so, I think makes a lot of sense. I would definitely, you know, shift it to Bill for the bioethics implications there.
Does anybody?
Or anybody else?
Clark?
Well, I would just add that I think you're going to find more progress in that area from legislatures than from courts. If you look at the past 40 years of American judicial decisions, courts have been the most hostile arena for the recognition of the humanity of embryonic human beings or developing human beings. Legislatures, through prenatal injury law, wrongful death law, fetal homicide law, and other prenatal protection areas, have created greater rights and recognition for embryonic human beings, and judges have been consistently hostile for 40 years, and you can name on one hand the number of judges who have defied that trend. And so that's why legislatures are the arena for progress in that area.
Okay, thank you. You want to close? Oh, okay, well, we want to thank you for coming. We want to thank our panel and Dr. Charmaine Yost. And we have a resource table out there for any materials to pick up, and some of us will be around if you want to ask additional questions. And just a reminder, there is the event tonight, which you can still sign up for, right? Okay, thank you very much.